Welcome to the 33rd episode of Certain Group's podcast, Alternative Litigation Strategies. I am your host, Kevin Skrzalski, a director at the litigation consulting firm Certain Group, where we provide the nation's largest platform of litigation risk management solutions. I am very pleased to be joined by a colleague of mine for the first time in 3 years, Bryce Barcelo. Bryce, good morning. How are you?
Morning, Kevin. Thanks for having me on.
It is my pleasure. So today we are going to discuss all things intellectual property and artificial intelligence. Bryce is the director of our IP strategy here at Certum Group. He leads our IP licensing, funding, insurance, litigation, and acquisition strategies. And he is also a professor of patent litigation at the Houston Law Center. And so he is a great person to discuss all of these things here today, which are very novel and interesting in the marketplace. I know that about 2 sessions ago, I had a guest on and we discussed everything that had to do with artificial intelligence and its impact on the practice of law and workplace efficiencies. And I want to capitalize on that. And I want to speak to you this morning, Bryce. I kind of want to start with piggybacking on one of my last shows on what role you see artificial intelligence taking in patent litigation, and if you really think there are any tools out there that are going to move the market and be trusted tools.
Yeah, sure thing. So when people think of AI, they think of this concept of, something that's going to come in and do your job for you. We're nowhere near that, and we're certainly probably not going to approach that anytime soon. But there are aspects of AI which I've already started incorporating into my workflow, and I've had discussions with other people about how they are incorporating into their workflow, and things I have not incorporated in my workflow through trial and error that has resulted in mostly error that I've excluded. So, the first thing I think is being very critical of the tool you're using. It's not necessarily going to benefit you to jump into ChatGPT and start trying to do your whole job through ChatGPT. It's funny, I was actually on a plane recently next to a surgeon, and I could see he was putting together a surgery plan, and he was copying and pasting bullet points from his surgery plan in and out of ChatGPT. And all I could think was, I really hope he's reading them after he pastes them, because I really don't want ChatGPT guiding my next surgery. But I, one of the tools I've used a lot is, and they don't pay me to say this, but Westlaw's co-counsel and research assistant AI. And the reason that those are, I think, are in a good spot with AI is generally right now just a fancy search tool. It's just the Google, of 2024, 2025 era. So, if you think back to what search engines looked like pre-Google, like with Ask Jeeves or Yahoo's basic search or something like that, I just think of this as the next iteration of search.
Let me ask you a question. I mean, is it Google on steroids, or, I was listening to a financial pontificator on the internet, and he said, if you're not using ChatGPT, you're basically an idiot if you're still using Google and not ChatGPT. Like, is that where we should be going?
No, I don't think that's right at all. Yeah, I don't think that's right at all. One of the absolute restrictions on using ChatGPT, or really most current AI systems as of today's date, at least, is that they're not up to date 100%. Google, for all of its failures, is up to date, up to the minute on happenings and news. And it's indexing that, but it's not processing it in the way that AI processes it. And that processing takes time. And it can't be done right now on a continuous basis as part of a model. It can be done as a temporary ingestion basis. And that's what I've seen in some other tools like Perplexity, which are very helpful in terms of getting more recent stuff or plugging in links or something like that. And ChatGPT has some of those features too. But absolutely, search is not dead in the traditional sense.
Right.
This is really more of a way to dive deeper when that subject's already been explored well. If it's an emerging subject, I think I would still go the search route, because it's just not going to be incorporated well into the model yet.
That is interesting, because you hear so many different opinions in the marketplace about what search you should be using and how much you should be incorporating, AI into your search. So that's insightful. Now, what do you think like the legal ramifications are going to be with, AI and incorporating all of this information? I know there was, the New York Times case against OpenAI. I believe that, they lost the motion to dismiss last month. I mean, what do you think is the right legal approach to, AI's development process in the legal marketplace and legal structures?
Yeah, that's a big question, but
I know.
I've thought about it some. I don't know that I have a definitive answer, but in terms of where I've made progress mentally on this question, I think that AI falls into a category for me, and this is, of course, something I'm still exploring, so no one should take this and run away with it, but I think of it as a human is a human. Like if a human was reading and doing all of this, where would we end up with? And if you have a human who is reading thousands of books, and then they're going out and they're building a website that provides answers, that aren't necessarily quotes from those books or shouldn't be quotes from those books, but that are answering questions in the style of that writer or in the style of that book's thematic elements or something like that. Most people, I think, would see that as all right, and I think the courts would see that as all right. The problem is that's not what AI is doing. What AI is doing is just vacuuming up all the data it can find, and you've seen this with the Facebook leaks, you've seen it with some of the OpenAI leaks. They're not just vacuuming up random stuff; they're vacuuming up huge amounts of copyright material. And in terms of Meta, particularly, they've been under some heavy fire for allegedly using illegal leaks or illegal downloads of unowned material from internet sources and incorporating that into the model because it's just easier to get it that way. And it's not something they have to then run through a bunch of corporate attorneys and do individual deals with all the publishing houses and things like that. And that's an issue. Unfortunately, at the same time, to build a really effective AI, you do need very large scale data. And I don't think we've found a way to technically solve for that without violating the rights of these IP holders in various ways. So, again, I think of it as if a human being was just doing this to the extent they could be, or 1,000 human beings were doing this to the extent they could be, and they were manually affecting it, it'd be one thing. But really what we're doing is we're taking a ton of, authors' books and materials and just shoving it in there. And who knows if those authors are getting paid. And it seems like most stuff coming out is indicating they're not being compensated for their work. And obviously that's an issue. I mean, if you're an author and like the artist from Studio Ghibli, for example, that's been very, famous recently. People have been Ghiblifying their portraits on LinkedIn and on Instagram and stuff like that. That is an art style. And certainly if you hired an artist and you said, I want to Ghiblify a portrait of me for a funny, portrait, they would do it. But that's talking to an artist about doing it versus that artist having all of that work stolen or misappropriated or somehow acquired and having all of that in some system where they just auto produce that. That's the transformative element is missing, I think.
No, I think that's a great point. I think, the conclusion here for the bottom line is the same as, my last show where I spent an hour discussing this, is that it augments human behavior, but it doesn't replace the human brain. And if you're going to be a lawyer and you took an oath and you have malpractice insurance, like a human brain needs to review all of this before it gets sent to a client or made public.
Yeah. Yeah, 100%. I mean, just a few days ago, I was reading about Mike Lindell's latest lawsuit and, how his attorney, Christopher Kokoroff and Jennifer DeMaster, that they generated a substantial portion of their brief, it seems like, using some sort of AI system. And the court came down hard on them. They, identified, I think, over 30 errors in citations and fabricated cases. And all of those kind of things. And, every now and then I post these to my LinkedIn. I haven't posted this one yet, but this one is one of the more particularly egregious acts I've seen. And, there need to be ramifications, I think, for doing this too.
Oh, yeah, I know. So, I mean, point well made. So, on the AI front, I've been trying to run this to the ground, with my guests for the past couple of weeks, couple of months. And we're reaching the same conclusion on all of this, is that, it augments, it facilitates, it's a good start, maybe a good first draft, but it is no replacement for the human brain, the human lawyer. And regardless of what some of the other pundits say, I don't think we're going to see that for some time. But anyways, pivoting off the AI front, Bryce, you've been running our IP practice for year and a half. Let's talk about funding. That's what a lot of people want to discuss. I know like half of our docket is intellectual property funding. I mean, what are you seeing with regards to IP funding, and what's working, what's not, what's trending?
Yeah, IP funding seems to be just absolutely skyrocketing right now. I think the latest, report, I think out of Burford that they published a week or two ago from today, really, is a strong evidence of that IP funding is just, it doesn't seem to have a predictable ceiling at the moment, and it just is. It's hot, it's burning, and people want to get into it. So there's a glut of opportunities out there. The same issues that faced me as a litigator, I now face as someone who's evaluating and directing this IP strategy for CERTM with these funding cases, which is, you got to have a strong case on the merits, obviously, and that's, everybody thinks they have a strong case on the merits, but a lot of the time, people are bringing IP funding into us, and I don't think that they have really analyzed the merits at the level of detail that a patent case requires and demands. And that's not their fault necessarily. They may just be unaware because we have so many new people entering the market. But there's a added layer of complexity, obviously, to patent litigation, and that translates into the funding evals and into the funding costs as well. So I do think that we're in a great place in terms of we're protecting IP rights holders, and we're getting plaintiffs their day in court that they wouldn't otherwise get. But at the same time, you don't want to be supporting a plaintiff or even suggesting to someone who would be a plaintiff that they should go take their case to court if, as someone with experience, it's just not going to be a good opportunity for them, and they're going to waste a lot of their time and potentially their own money too. So, there's always the traditional pitfalls that accompany it, but it's certainly exploding right now, and that's great, I think, for obviously for our business, but I think for anybody who's a patent holder themselves.
Right. And of course, before you joined us, you were a litigator, one of the most elite litigation boutiques in the country for the past 10 years, defending, many times mom and pop shops against some of the biggest Goliaths of the industry. And now I know you've recently spoken, to Bloomberg Law about John Squire's nomination as the USPTO director, and I believe he has some experience with litigation funding. I mean, how do you think his experience with funding will also tie into our business and impact this industry?
Yeah, so I was happy to be interviewed for that article because we have for the first time someone coming to the PTO, who's going to have a knowledge of this industry, and it's not going to be this, industry that people see as a mysterious, black box. I mean, it really is. It's really standing up for one thing, and that's to get people their time in court who can't otherwise afford it because the companies they're trying to fight, have basically unlimited resources. So, I think that we've already seen through, acting director Coke Morgan Stewart at the PTO, strong direction back towards supporting patent holders and supporting their constitutional rights that, are conferred by the patents they duly earn. And I think that Mr. Squires is going to, join the PTO and continue that that mantra that Stewart's put in place. And I think that's a good thing for obviously patent owners and IP rights, but also to help shift some of that burden back towards the middle that defendants have been able to push so much onto the patent owners. I think that's supported by having that background in litigation funding, because you understand more from a global perspective, litigation, the throes of litigation, the demands of litigation, the costs of litigation, and how hard it is for, someone who might have just not had a great startup experience or couldn't find the right funder or something, but they have great IP, they have great assets, and they just have not been able to monetize that effectively. And meanwhile, they're being efficiently infringed, as defendants love to use that term, in the market, which is obviously, to their great detriment, because it not only devalues their ability to conduct their own business, but oftentimes it pushes them out entirely. Or, in the worst cases, they're individuals who have gone to those big companies and had their IP directly stolen as a result of those meetings that are often under NDA too. So, it's tortious, and it's not what we want as litigators or as practitioners of the law. So, yeah, I'm looking forward to a little bit of a shift back towards the middle from Squires and Stewart.
Yeah. Yeah, I hope so. And we see that all the time. I mean, some of these inventors and some of the clients we have, I mean, these are such brilliant engineering minds, and just to see their inventions, taken by bigger companies like Goliath, they used to go against. It's refreshing to be able to fund these cases and help them, defend their intellectual property and defend their inventions.
Absolutely.
Well, Bryce, I appreciate your time here today. I think this was an incredibly, valuable and insightful conversation in terms of artificial intelligence and what's happening currently in the world of litigation funding and intellectual property. Now, being a professor, at the University of Houston Law Center, I have to ask you a final question, and it's one that I ask most of my guests, which is, if you were speaking with a undergraduate or a law student today who wanted to consider a career in law, or even if they already are aware that they would like to go into intellectual property law, what guidance, counsel, and advice would you give to that person, to our younger generation?
Yeah, it's a very relevant question, I have to say, Kevin, because I've got both scenarios right now. I've actually got, a niece of mine who is finishing up her undergraduate year and has a strong desire to become a lawyer, and has been in the entire process of, doing the LSAT, applying to law schools, and she's, waiting on some final decisions now before making her decision. And of course, I also, teach. So, my law students are generally 2Ls and 3Ls. This semester it happened to be a lot of 2Ls. And so there's a lot of advice, I think, that I have to provide to them, and it's been helpful. For an undergrad, I think there's a really, the question overarching you is, do you really want to become a lawyer, or do you think you want to become a lawyer? And I find, from talking to my niece and from talking to other people in her position, they think being a lawyer is one thing, and maybe we were all guilty of that at one point when we were younger. But being a lawyer is so many different things, and so different to the individual too, and how they want to practice law, what field of law they want to go in, and knowing that is sometimes as hard as knowing what your undergraduate degree is going to be when you're a freshman in college. You just don't really know, because you can't know what you don't know. And so, getting educated, I think, as an undergrad is super important, not just saying, hey, I want to go to law school because being a lawyer is cool. I've watched Suits, and that's definitely how they do it.
Right.
But, I think you have to educate yourself, especially on the financial requirements of becoming a lawyer. It's very expensive now. It's very competitive, just because you have a law degree does not mean you're going to go out and get some well-paying job in the market. You're going to be competing against the most people that have ever entered the legal field in this country, every, preceding year. And so, why are you becoming a lawyer? Ask yourself those questions. Look at the industry you're thinking about going into, and do a thorough amount of research, and absolutely try to find someone who's in that industry, that is in your network of connections that you can trust, and talk to them and get advice, because they're going to tell you about their day and their, routine, and what they do, and the difficulties that a lot of lawyers face, and all sorts of issues. And I think that is the most important thing before even taking the LSAT, is getting a sense of, is this right for me? Because it's not right for everybody. And we all saw people, during law school who thought it was the right thing for them, only spend a ton of time, effort, money, headache, just to drop out first or second year. And just have to restart kind of from that time. Now, on the law student side, the people who I say have already made this mistake, I think for them, they're in a situation where, okay, great, they're sure they want to become a lawyer, but once you're in law school, you're learning so much, you're getting so educated that you actually may not know by your 3L year that what you wanted to do your 1L year has transpired. And I use myself as an example of that. I joined after being a rocket engineer for United Launch Alliance, and I thought, well, I certainly don't want to waste my valuable engineering background that I worked very hard to obtain a degree in. How can I leverage this? And it seemed like the clearest way was to go into patent prosecution, drafting patents and getting them through the PTO and things like that. I was very sure of that, actually. I took all the requisite classes. I worked for a patent prosecution firm for an extended period, both during the summer and during law school classes, actually, downtown. And, I actually enjoyed that work. But kind of through happenstance, I found myself in the Inn of Court in Houston and met some people and, got familiar with the litigators and just had a litigation opportunity arise that I could join right after my 3L finals. And so I thought, hey, why not? Let's give it a shot. Never having thought really before May of my graduating year of law school that I would ever want to become a litigator. And then I spent 10 years there, 10 years in a career path that I had never contemplated, through pre-law school, through 3 years of law school, through summers in law school and other jobs in law school in various IP facets. So, it's something that you got to be flexible. You have to be flexible, and you need to talk to people constantly, and you need to think about the classes you're taking and really get to know your professors, because they're your professors and you want to have a good grade and you want to make sure you're learning the material. But also, they're oftentimes people who practice law for a good stretch or are currently practicing law if you have adjuncts. And so they're going to be, a valuable resource you should lean on as much as possible. And that's something I stress to my students at the beginning of our class, in our first class, and then again in the last class of our class, because I don't want them to think, that just because the class is over that I'm no longer a resource for them. I want them to reach out. I want them to add me on LinkedIn. I want them to email me, because, when you're a 2L, you still have a lot of decision making to do, and you need to know people. And when you're a law student, your lawyer network is probably not very extensive.
Bryce, I think that's one of the most excellent answers to that proverbial question that I've asked about a dozen times on this program. I've worked with you for about 2 years, and I did know your story. I think it's fascinating and it's magnificent. Just to digress a little bit, the last person I had on the program, thank you, was Will Mara, who teaches at the Penn Carey School of Law, and he teaches litigation funding. And we actually were doing this contest where the top student would possibly come on my podcast. They'd win an award, and they would discuss what they learned in the class and what their big takeaways were, and how they were going to leverage what they learned in your class into the potential career. And I posed that to Will and his colleague at Penn, and I happily propose the same to you as well. I'd love to get some students on this program.
Yeah, I think that's an excellent idea. I think that it's great exposure for them. And, obviously, if you work that hard in one of my classes, I want you to get a reward of some sort. And usually I just give out law firm swag that I've accumulated over the years.
Free stuff from conferences. Yeah.
Yeah, someone got a Sussman Godfrey pickleball set this time. So that, I don't know how much.
Let's get, we're like your top 2 or top 3, and let's do a round table on what
good idea.
Kids learn and what they want to do with their futures. I think that'd be pivotal, and it's very interesting to the market. So just to wrap up, and man, I don't want to jam your email and your voicemail. However, given all the thoughts you've shared here today on funding, AI, and a potential career as a lawyer, would you like to provide some of your contact information so anybody who listens to the program can reach out to you and discuss these ideas further?
Yeah, absolutely. Probably the best way to reach me is via email. My email is bbarcelo@certumgroup.com. My inbox is busy, but it's not so busy that I don't notice things come in, because I'm an inbox zero guy, even though everybody thinks I'm insane for that. And then, of course, my phone is another great way to reach me if it's more urgent. 713-398-4159.
Again, Bryce, very much appreciated. Thank you for joining me on the program. It's always great to have a unique colleague as a guest, and I thank you for your time today.
Thanks, Kevin. Thanks for having me on, and thanks for the insightful questions.
Absolutely. And of course, if anybody would like to contact me, you can get a hold of me at kevins@certumgroup.com. My direct dial is 216-570-9370. If anybody would like to discuss any of the litigation risk transfer solutions, including any of the insurance or funding products that we offer, always happy to take your call at certumgroup.com. And until next time, I thank you for your time.
Thanks again, Kevin.